of the university. All right, let me just bring in my guest right now here in studio, Felix Odhiambo. He is an electoral law and governance expert. Thank you very much for joining us on the show.
Thank you.
All right, so first things first, I'd like to hear your reaction to everything that has been happening with the students. I mean, you saw the videos, quite a number of reactions. The IG says that, the students were being frog marched to quell, a situation. The CS for Education came out and said that, investigations are ongoing. But this investigations narrative is something we've had so many times as Kenyans. What is your take about everything that has been happening in the university?
Well, first of all, I think it's extremely unfortunate that 5 years or 7 years since we passed the new constitution, that is hailed as having one of the best chapters on the Bill of Rights that entrenches and protect, among other things, the right to picket, that this country still faces challenges in so far as recognition of that right is concerned. And in the 70s and the 80s, running battles with the universities, the police and the security sector using repressive laws to suppress lawful picketing was the order of the day. But many, many years later, after passing the new constitution, that the students of the university, or any other person for that matter, cannot protest or picket to protect a right. It is extremely unfortunate. But one thing that I've often said also is that whereas we passed the new constitution, we have been very slow at instituting reforms on the security sector. Our forces of maintaining law and order are both lawless and disorderly. Just look at how, and the excessive force that they used to beat, including women, by the way, our female students, so to speak. It just is a confirmation that our forces of maintaining law and order are extremely trigger-happy and are both lawless and disorderly, and it's an extremely unfortunate situation.
Yeah, and like I mentioned earlier, the CS has come out to speak, IG has come out to speak. Yesterday, the Vice-Chancellor, Peter Mbidi, came out and said something. But do you think they're being honest, really? If, the CS says that, they don't trust the originality or the source of the videos that, we've been seeing all over the place on the internet?
It's unfortunate. I mean, they are completely dishonest. And I think they are being very economical with the truth. Now, the irony with the CS, the acting CS Interior, which many people do not know, is that he's a product of the civil society. When we were with him at the civil society, he embraced and preached and practiced the very rights that is now at the helm or at the forefront of violating. And it's a question or a classical example of how people change. 5 years since he was appointed the CS, and a few months since he was appointed the CS Interior, he's actually attacking the very rights that he defended while he was the head of SUNY, State University of New York, which was working with Parliament. Now, every time I see the Inspector General of Police speak, I take it with a pinch of salt and gives it the contempt that it deserves. All right. Because there's no truth or honesty to what he says.
To what he says.
Yes.
And also just expanding the conversation from the University of Nairobi. And yesterday we saw, NASA supporters come out to picket. But even here in Nairobi, even before they were given the chance to do so, police already came in and, dispersed whichever groups of people were there, even without, sort of like filtering between any criminals or people who had come out to support. And even just listening to Kenyans, there are people who are saying we actually came out peacefully to demonstrate against IEBC, but that did not actually happen. Yeah. What does that say about where we are? They don't even get to picket because of the police.
Absolutely, and it is a constant violation of the right to picket. One of the reasons why this constitution is hailed as transformative and progressive, and incidental in this country, is probably only the judiciary that has internalized the progressive nature of the 2010 Constitution, is that it has protected, elaborated, and made expansive provisions on the chapters on the Bill of Rights. Now, that chapter 5 compels the state and state entities not only to protect and respect the right, but to give it or to adopt an interpretation that does not curtail the enjoyment of that right. In fact, that expands the enjoyment of that right. Meaning, if we decide, or if NASA or the students, university students decide to picket, it behoves the state to protect that right to picket. Now, in Kenya, we embraced a new constitution with the mentalities and the mindset of the pre-2010 constitutional dispensation. And that is why we repress and brutalize people who try to exercise that right. The police use excessive force to quell or to quash the enjoyment of that right. And I think, and more so, by the way, when it borders on realizing a political right. The state is more ruthless in its repressive acts.
All right. And the pictures that you had been seeing on your screens are just the students of the University of Nairobi leaving the campus. That directive was given some time ago, a few moments ago, for them to vacate the premises indefinitely of the university. So the students there saying that, they were just going about their day until that directive was given from the Corporate Affairs Office for them to leave the campus. So we'll be covering that for you also here on KTN News. But coming back to our conversation, Felix, earlier on I was speaking to the Member of Parliament for Pokot South, David Picossin, and he has a very interesting petition in court. He wants to compel NASA leader Raila Odinga to participate in the October 26th election. What is your take on this?
I heard it, and I've followed it on the news, actually. And I think, in my honest opinion, that is a misinterpretation of the Supreme Court ruling. And if you hear the grounds for his petition, is to compel Raila to participate in the October 26th election.
Yes.
And to the best of my recollection, Prime Minister Raila Odinga has not indicated that he's boycotting the elections. He's indicated that the election, when the August 8th election was invalidated by the Supreme Court, the Supreme Court cited illegalities and irregularities. And what it meant is that, and the Supreme Court was very specific in prescribing the test that the Constitution imposes on a free, fair, credible elections by citing a number of articles in the Constitution, but most prominently Article 38 on political rights, Article 81 on the principles of voting, and Article 86 on the conduct of elections, and especially the presidential elections in this country. What it meant is that even with the Supreme Court ruling, there are certain administrative arrangements that needed to be put in place. And by the way, and for the record, the majority decision of the Supreme Court did not suggest that we needed to enact an election amendment law. What the development you're seeing is actually the Jubilee administration taking the minority dissenting opinion of Judge Jokindungu, which sort of prescribed that certain amendments needed to be put in place. Right. Now, I've maintained that there are fundamental errors and problems with that dissenting opinion, but most fundamentally, in any jurisdiction, a minority opinion is just that. It is a minority opinion. It will never be cited anywhere. It will never be binding on any lower courts. The decision of the Supreme Court is the decision as rendered by Chief Justice Maraga, Isaac Lenaola, Mwilu, and Smokin Wanjala. Anything else is an academic exercise. Now, the Honorable Member of Parliament, David Picossin. Yeah. I think that is the misunderstanding, first of all, that is coming from. Instead of focusing on ensuring that the elections, the repeat presidential elections, is held in accordance with the Constitution, is actually jumping the gun. How or where this will reach, I think the courts will pronounce itself on this matter, so we can't speculate. All right. But I think it's based on fundamental errors in law. All
right. Yeah. Let's now come back to, today we have the public participating on the proposed Electoral Law Amendment Bill 2017. And, quite a number of issues. It's really contentious. You have people supporting it, and of course, another, section of people really against it. And yesterday I was speaking to a Member of Parliament for Funyula constituency, And he said that it's not really about the proposed laws, but it's about the process. Is it really about the process, or, are there fundamental issues to do with those proposals?
I mean, they are both, actually. It's about the process, but also the content of the so-called proposed amendments that Parliament is discussing right now. Let me say this for the record. This is the most unfortunate piece of legislation since the Mlolongo voting of 1988. And unfortunately, the most unfortunate piece of legislation under the 2010 constitutional dispensation. There have been attempts, in fact, in the past, to enact laws that were utterly oppressive to the Constitution or the principles and the spirit of the Constitution. The media law, I'm sure you remember that, but also the security sector law.
Yeah.
But none of that compares with it. Now, for the record, every time that this country, and if we walk as far back as 1963 when we got independence, every time we as a country have attempted to legislate or to come up with a legislation that introduces mischief in our body politic, the greatest losers has been Kenya, the country, so to speak. In 1966, the so-called Turncoat Amendment that introduced that when KPU was registered, Parliament rushed in against all odds and against all parliamentary process and procedure to enact a legislation that required that the KPU members had to vacate their seats and seek a fresh election. In 1974, there is an amendment called the Ngei Amendment, when President Jomo Kenyatta then could not pardon an election offender. Parliament rushed a bill, processed a bill within 1 day, passing through the 3 stages, and in the evening, it was passed unanimously, and President Jomo Kenyatta assented to it, and then pardoned
in a day.
In a day. And in 1982, when this country negotiated, introduced Section 2A that outlawed multi-party politics, again, it went through all the processes of Parliament within 1 day, and it was assented to by President Moi the following day. And then, of course, the Mlolongo voting of 1988. Now, this is the intention of Parliament. And before they adjourned, there was a request by Parliament to be able to circumvent the known parliamentary processes and have this bill go through all the stages within a day. Yes. This is the intention of Parliament. But most fundamentally, to underscore the point that I said earlier, the majority decision of the court did not imply or contemplate any amendment to the law. What it required was a change in attitude. A change in attitude in the conduct of elections. And that is why Judge Maraga, as he was reading the orders, said that a fresh presidential election in a strict adherence to the Constitution and election laws. He wasn't suggesting that there was inadequacies in our legal framework for election. And so why the Jubilee administration can pick on a dissenting opinion, and there are fundamental errors with Njoki Ndung'u's dissenting opinion, fundamental errors, but maybe we don't need to get to that. What they are doing is to elevate a minority decision. You cannot base an election sector law reform on a dissenting minority view of a judge.
All right. Yes. Interesting. And I just want us to delve deeper into some of the issues. And President Uhuru Kenyatta has been extremely vocal, even as late as yesterday, came out to say that he really doesn't understand, the noise that's coming from, different people about this proposed laws. And he says that, these laws are trying to correct the mistakes that came about from the Supreme Court ruling that nullified his elections, talking about, the errant presiding and returning officers, that they should be punished. And he's asking, what's wrong with all these proposals? Let's just take one at a time.
And by the way, as you've exactly said it, if you hear the defense by Jubilee legislators over these amendments, it is based on just one fact, and that is exactly what you've said, that, this will compel the returning officers and the presiding officers to append their signatures on the forms. They are not dealing with other fundamental flaws in this legislation. Now,
so they're just concentrating on one?
On one at a time. Let us take, and there are basically 3. The first one is the conduct, an amendment to the IEBC Act of 2011. and the whole relationship of the quorum of the IEBC, but most fundamentally, the person or the chairperson of the IEBC.
Yes.
In 2011, when we were deliberating on the IEBC Act in Naivasha, and I was glad I met the former chair of the Justice and Legal Affairs Committee, who was just coming out of your studios. One of the recommendations that we said that the 10th Parliament quashed was that we ought to have introduced the same qualification of the vice chair to be in tandem or in sync with the qualification of the chair. In the previous election law, the National Assembly and Presidential Elections Act, the qualification of the chair and the vice chair were the same. And that was the requirement that they had to meet the same requirement as the Court of Appeal, which was the highest court then.
Yes.
The justification and the reasoning is simple. When the chair of the IEBC exercises his mandate, is exercising a quasi-judicial role. When he looks at, scrutinizes the election laws and makes a reasoned judgment and interpretation of that, is exercising a quasi-judicial role. When he looks at the statutory forms, forms that have been declared, 34s, etc., is exercising a quasi-judicial role. And that is why it was prudent then that we needed to have the same requirement for the chair and the vice chair. In the Election Commissions Act of Ghana, the chairman and the vice chair have the same similar qualification, and that is the qualification same as the judge of the Court of Appeal. Now in Kenya, in the previous dispensation, Kivuitu and Mukele had the same qualification, and that is how it should be. Now Parliament shot that down. As it is, we don't. It's only Chebukati that meets this requirement.
Yes.
Now, if Parliament did not legislate that, the requirement of the chair is different from the ordinary commissioners. Now, if you pitch this to the Constitution, Article 250 of the Constitution that recognizes the constitutional commissions and makes a distinction of the chair and ordinary members. Now, you can never assume that these requirements are the same. So this is to circumvent or to introduce or to normalize something through the back door. So it is on that basis alone, it is not only unconstitutional, but it is also illegal, but also does not reflect on any known best practice.
What would be the benefit of them, downsizing these credentials of the chair? What would be the benefit for Jubilee Party as is?
Well, that would also offend the Constitution in this way. I've argued elsewhere and in a number of forums that if you look at the Chapter 15 commissions, the Constitution elevates the IEBC, the Independent Electoral and Boundaries Commission, over and above every other commission, for the simple reason that the Constitution has introduced sovereignty, and sovereignty is exercisable through elections, and the body that is mandated to supervise us is IEBC.
Yes.
That elevates IEBC over and above the Ethics and Anti-Corruption Commission, for example, or the Kenya National Commission on Human Rights, period. That's a point. Now, because of that elevation, it therefore goes without saying that the requirement of the chairman of that commission must be pitched at a higher threshold. Any attempt to whittle that down is to offend the Constitution and emanates from a wrong interpretation of the Constitution. That is one. So, I mean, we can't afford to go that direction.
And Felix, let me ask you a difficult question. What would be the reasoning behind wanting to do exactly that to the chair of the IEBC?
And that is precisely the point. To answer that, you also need to ask yourself one question. Did the Supreme Court find fault with the composition of the IEBC as it is? The answer to that question is no. Now, why would Parliament seek to legislate on something that was never flagged out by the Supreme Court? That is the first question. And so, and it is suspect. I've heard in other forums that, there was apprehension that Chebukati knew that is the only person who meets this requirement, and that therefore it was planning to resign. And if he did, that would have thrown the country in a constitutional crisis. Now, if you look at the patchwork, which is that particular part of that provision, it's probably emanating from that fear and that apprehension.
All right.
And that is why it is so poorly worded that, the vice chair will act, or the IBC commissioners may appoint one
somebody
to act as a chair.
Right.
That is utterly
So
unconstitutional.
you're calling it patchwork.
It's a complete patchwork.
Interestingly. Yes. The other issue that, this one of the other proposed issues is that if in this case, and actually this is an ideal situation where we are, where Raila Odinga says, I will not run with everything as is. And one of the proposals is that if there's nobody to challenge President Uhuru Kenyatta or any the president at that time, he would be declared the president-elect. What are your thoughts on that?
Again, that arises largely as a result of apprehension. That Raila Odinga has indicated that he's not going to participate in the repeat election, and that therefore any partial election that is held without conforming to Article 138(2) of the Constitution that requires a presidential election to be held in every constituency, 290 constituency, would be invalidated. Yes. I mean, that is the point. And like I said earlier in response to the petition that the Honorable MP had launched, I don't think Raila said that he's boycotting the election. He's saying that what the Supreme Court said is that there were irregularities and illegalities. Now, that requires certain changes, mostly of administrative nature, not... By the way, there was no, and I've often said, what the Supreme Court said in their majority decision does not require an amendment of the law. It doesn't. It requires certain administrative changes. And so I think the sneaking in that provision to require that in the absence of president running, in the absence of a candidate, yes, or a one candidate, only in that election, it should be declared. This election is an Article 140, as they have said, is an Article 140 presidential election. It is not the repeat presidential election. It's not going to be an election under Article 138. This is the point that, again, they are missing. All right. And so they really need to think on that. But there is also another issue with regard to the bill before Parliament. And that is to see an attempt to give or ascribe an interpretation on Section 83 of the High Court. Of the Elections Act of 2011. And this is how. That if an election is held substantially in a manner that violates the Constitution and written laws, but that this election should not be invalidated on that point alone. Now, you look at that amendment and look at Article 38 of the Constitution, Article 81 of the Constitution, and Article 86 of the Constitution. What the Supreme Court did was to affirm the higher threshold that the Constitution of Kenya 2010 imposes on a presidential election. To reason and to argue that let us just hold a sham election. As long as it cannot be proved that that election, the violations of the law did not affect the results, then that election passes. It's a pre-2010 mindset. We have a new constitution. At the very least, we must try to comply with it. So that particular amendment, as they're proposing it, is to rectify what the Supreme Court did. Because the Supreme Court substantially rendered its decision and gave an interpretation to what Section 83 of the Elections Act. Now, to try and go through the back route is to take us back to the 2013 jurisprudence. Right. And then, of course, the jurisprudence before 2010 Constitution, and that is extremely unfortunate. Then finally, they're talking about the old distinction between technology and election. Yes. Now, this emanates from Justice Njoki Ndung'u dissenting opinion. And I saw, with all due respect, and she's my friend, the judge saying that there is a confusion and that there is a mongrel between technology and manual transmission. This view has been made by the Attorney General in a number of forums, that the Kenyan constitutional and the legal architecture for election is manual. Now, both views are erroneous. The Constitution under the Elections Act, as it relates to voter registration, as it relates to results transmission, as it relates to voter identification, is electronic. and backed up by complementary mechanism. It is not a mongrel, as Justice Njokindungu suggested. She misread that particular law, and I think she based that on what the Attorney General has said repeatedly. And they are saying that Kenya does not have electronic voting, and that is true. And by the way, what the two are missing, especially the learned judge, is that there is no country under the sun that has attained 100% electronic voting.
Right.
There is none. So it is always a combination
yes.
or a complementary mechanism. Yes.
Now, with everything that you said, Felix, and, the wheel is still rolling. Like right now as we speak, people are submitting memoranda. Public participation is currently ongoing. This wheel is rolling. Is there a way out? Do you really, at the end of the day, has the numbers? NASA has said it will keep off from everything that's happening. Really, is it exercise in futility?
Well, even if Jubilee succeed to legislate on this, let us also remember that the rogue parliament that was the single-party parliament legislated on the 1966 amendment, as I've said, legislated under passed Section 2A that outlawed multi-party democracy, legislated and they used their tyranny to pass a legislation that introduced Mlolongo voting. Just because the majority are doing it that is not a reason or is not a ground for those with the conscience, those who want to pitch our election and consolidate our election democracy and pitch it to the Constitution. It is not an exercise in futility. Now, but for us, we must constantly make this point. The way the Constitution of Kenya 2010 contemplates an election is a qualitative election, an election that meets with certain provisions of the Constitution. The Constitution has set standards and thresholds for holding elections. Parliament, even if they succeed in legislating on this, cannot run away from that. But I can promise you, if this bill is passed and is challenged in court, the judiciary will almost quash substantially most of its provisions because it offends the Constitution.
All right. Yes. So we're looking at a very long process after here. Yes. All right. So I want us to move away from the proposed electoral laws and just to come back to what the envoys said yesterday, still touching on this bill and also what NASA is fronting for, and saying that, we should not give so much pressure and put so much pressure on the IEBC. But really, going back to the Supreme Court ruling, IEBC was really at the center of why this election was nullified. So how do you then balance between not giving them too much pressure, but also holding them to account to give Kenyans another presidential election that will not be questionable?
I mean, I watched the envoys, and let it not be forgotten that the same envoys and international community gave this election a clean bill of health and used terminologies that some of us who are in elections find serious problems of using, and that is the elections was free, fair, and credible. And thank God, soon after, the Supreme Court process began, and the Supreme Court invalidated the election, citing illegalities and irregularities. And to a larger extent, most of the envoys have actually been, eating a humble pie. Or taking back their words. They are right in suggesting that to get out of this present predicament, we need a bipartisan approach, and we need a political solution that can negotiate and can compromise on a number of issues. It will require a give and take situation. NASA would have to come down on the irreducible minimum. Jubilee, on the other hand, would have to come down on, it's a give and take situation. But where the envoys are wrong, and I heard the Honorable MP, and I've heard this narrative being repeated, being discussed all the time, that the Supreme Court did not find criminal culpability on the IEBC. And the truth of the matter is, the Supreme Court was sitting as an election court. It wasn't sitting as a criminal court. But the Supreme Court found that the IEBC was culpable for having committed irregularities and illegalities. Now, the buck stops with the IEBC. When I say that what the majority decision was did not require an amendment in the law, it required institutional and administrative changes on the IEBC.
Right.
We can't run away from that. If you look at the body language of IEBC over the last 5 years, there is no single procurement that Ezra Chiloba, the CEO of IEBC, got right. And you can only cite two: the procurement of the ballot papers and the procurement of the schemes system.
All right.
And the KIN scheme. We never got it right.
All right. Felix, allow me to just interrupt you for a moment. We'll come back and finish our conversation.